As people know, I'm Toby Rothschild, and I'm an ethics presenter, a longtime legal aid lawyer for the last 55 years or so. And we're going to talk today about ethics for legal aid lawyers. Oops. So an overview of what we're going to talk about today. We'll talk about the general overview of ethics, talk about ethics with a capital E versus ethics with a lowercase e and what the difference is and why. We'll talk about common ethics issues and then specifically special issues in legal services. And if time, we may talk about some new developments. So, what is the law of ethics in California? Well, it starts with the State Bar Act, Business and Professions Code, and then comes the Rules of Professional Conduct. Now, this is unique in the state, in the country. In every other state, the Rules of Professional Conduct, adopted by the Supreme Court or its equivalent, is where you find the rules governing lawyers. But in California, the legislature, through the State Bar Act, also regulates lawyers. And that becomes important sometimes when you need to look at both and not just the rules to know what you have to do and or not do. You also find things in the rules of court. You find things in the evidence code, like attorney-client privilege and the definition of a writing. So some things are required to be in writing. Evidence Code Section 250 has a very broad definition of what a writing is. Good thing to know about. And there's other codes. Virtually every code has something that affects lawyers. So you've got stuff in the family code, in the Code of Civil Procedure, in the civil code, government code. Probably find things in the water code if you look there. But almost every code has something that affects the practice of law. So, where do you find the ethics that we just talked about? Where do you find those things? Well, good source to start is the State Bar website. The ethics page on the State Bar website has lots of good stuff, including the rules and the statutes. You find State Bar Publication 250, which is an 8.5 by 11, used to be one, now 2-volume paperback book that's available for purchase on the State Bar website, or you can actually access it completely on the website. It's got the rules, the statutes, previous rules if you need those, other rules affecting lawyers, some code sections from other codes. It's got the IOLTA rules, it's got the MCLE rules, all of those kind of things are in publication 250. The California Compendium on Professional Responsibility is really an amazing thing. It's 3 loose leaf 8.5 by 11 volumes that's updated every year, that have all of the local bar ethics opinions, the State Bar ethics opinions, other resources. But the most important part of it, the compendium itself isn't on the website. You have to pay for it. But what's really available on the website and really useful is the index. The index is about 500 pages long, and it covers virtually everything. And you can find cites to statutes, to rules, to cases, and it just to ethics opinions. If you need to find something and you're looking for a way to get into the research, the index to the compendium is really an excellent start, and it's available on the State Bar website ethics page. There's also the ABA model rules and professional responsibility. You've got a cite to those there. The ABA rules are not binding in California. In fact, they're not binding anywhere. They're only model rules. Every state has adopted something along the lines of the ABA rules, but all of them have their own differences. But it's important to know that California's rules are probably more different than the ABA rules than any other state. It's only in the last 6 or 7 years that California's rules even looked like the ABA rules. They used to have different numbering system, different format. Now they're at least, you can find your way through the California rules if you know the ABA rules. but you shouldn't rely on anything in the ABA rules to do your research. Sometimes ABA rules can be interesting to use, not to rely on, but to use as a guide to where things might be going, or where they are in other states. And sometimes if California is silent on an issue, they'll look to the ABA rules to figure out what to do with that, but not always. You also have appellate court cases. You've got the state bar court, which handles discipline matters. They have published opinions. And then you have ethics opinions coming from the state bar, from the California Lawyers Association, and from about half a dozen county bars that have their own ethics committees that issue opinions. LA, Orange County, San Diego, San Francisco. I think there's a couple of others that do that too. And those are important to follow. So let's look at, continuing the overview. The rules are not black and white. They're shades of gray there. They're not absolute. So you need to look at why this rule was adopted, and what is it really was trying to encourage or prevent, depending on which direction it goes. And they're considered by the bar as rules of reason. Sometimes they permit or require a risk-benefit analysis. Why was this rule adopted? What was it trying to accomplish? And is what I'm doing or thinking of doing, or unfortunately did sometimes, does it really get to what the bar was trying to, and the Supreme Court were trying to get at with the rule? Sometimes you'll find that it's totally unrelated, even though that might look like it's a violation of the rule on its face. The rule really was aimed at something totally different. And so then you might think about, what's the risk if I do this? I might get disciplined. Somebody might complain. And what's the benefit to my client if I do this? And what's the risk actually that somebody will, first of all, find out about it and then complain, and then that the state bar will care about it and do anything? So it's an issue you sometimes need to look at and figure out, do I need to, what I need to do in this context? So uppercase E, lowercase e ethics. Uppercase E ethics is the rules of professional conduct and the State Bar Act. They're the rules of the road. It's like the vehicle code. They're external to you. They're useful for discipline, for disqualification, even though the rules say they're not for that purpose. Courts use them for that. They're useful for guidance, and courts use them in malpractice cases. Again, even though there's some question whether that's appropriate, they in fact are regularly used that way. So that's the uppercase E rules, rules of the road. Lowercase e, ethics, is morality. It's what's right and wrong. It's internal to you. It's what you believe is right and wrong, as opposed to what the rules say you can and can't do. And sometimes those will conflict. And when it conflicts, you need to think about which one you're going to follow. The probably leading discussion of that was a couple of public defenders in Chicago were defending a client named Andrew Wilson from a murder charge. And they were defending him. And in the course of that discussions with him, he mentioned that he had committed a different murder, that he had killed a security guard at a McDonald's restaurant. He insisted that they could not tell anybody that he had done that. The ethics rules have a very strict confidentiality provision, so they didn't say anything. Mr. Alton Logan then got charged with that crime. And they asked him, well, could we at least hint to the DA that they have the wrong guy, that they might want to look for someone else? Nope, can't release any information about that. So Alton Logan was convicted and sentenced to life in prison. And they kept pushing to see, could they convince him to let them say something? And he would not. Finally, they persuaded him that once he died, once Andrew Wilson died, they could disclose the information. So at the time that they first learned the information, they wrote a declaration setting forth what they had learned and locked it away in a lockbox. So when Mr. Wilson died 26 years later, they released that information. Mr. Logan was eventually released, was exonerated and released, and they had lived up to the letter of the rules. Other people might have made a different decision there based on their lowercase e ethics. Was it worth it, Mr. Logan spending 26 years in jail for those lawyers not to be disciplined and lose their license for disclosing confidential information? That's the choice they made. They were asked later if it had been a death penalty case, would they have made a different choice? And the answer was yes. They wouldn't have let Mr. Logan be killed by the state if it had gotten to that point. Most people don't face that large a decision, that important a decision, but it's not unusual that you'll have a situation where what you think is right and wrong is different from what the rules say. And at that point, you have to make that decision for yourself as to how to proceed. So what are the common ethics issues that lawyers run into? Starting point is that rules are the same for legal services as they are for everyone else, with a few exceptions. And we'll get to some of those later, but they're not major exceptions. One is conflicts. One of the issues, big issues, is conflicts of interest. The other is confidentiality. Those are the two areas that most of the issues arise around. So let's dig into those a little more deeply. So Business and Professions Code section 6068E and Rule 1.6 are the places we're looking here. Now, Business Professions Code 6068 is an interesting section that everybody should probably look at every once in a while. It begins, it is the duty of a lawyer to, and goes on from there with A through, I think it's P or O, a lot of subsections, that it's duties of the lawyer. So it's worthwhile to look at what your duties are every once in a while and see what's required. E is probably the most commonly cited one. And it says, E1 says, it is the duty of an attorney to maintain inviolate the confidence and at every peril to himself or herself to preserve the secrets of his or her client. Very strong language. Look at that again, to maintain inviolate the confidence. Now that is usually seen as talking about confidential information, but in fact, they're talking about confidence in the normal sense of the term. They're talking about maintaining inviolate the relationship of trust and maintaining that confidence of your client that you're going to be his advocate or her advocate, and that you will maintain confidentiality and that you will work exclusively on their behalf. And at every peril to himself or herself to preserve the secrets of the client. Now the client, the secrets in this context is, again, a term of art, and it means anything that you learn in the course of the representation from whatever source that might be harmful to the client if it was disclosed, or that the client doesn't want you to disclose even if it wouldn't be harmful. There's very few exceptions in California to 6068E. The ABA rule 1.6 has a number of exceptions, I think 8 or 9 of them now, and it keeps growing. California has 2. One is consent of the client, and the other one is 6068E2 that we'll get to in a minute. So, what is it that's covered? Anything that is covered by 60681, that is, confidences and secrets are confidential. When does it apply? It applies forever. It doesn't end when the case is over. It doesn't end when the attorney-client relationship ends. It doesn't end when the client dies even, or even when the lawyer dies, because his files remain confidential. Who does it apply to? Everybody within the attorney-client relationship. So that's not just the lawyers, but the staff, the paralegals, the volunteers that are working on the case, the interpreters, social workers, anybody who's involved in that case and within the firm is subject to this confidentiality. It means they can access that information, but they can't reveal it to anybody. And that means they can't release it to family, to friends, to anybody. So where does it apply? Everywhere. You need to be careful anywhere in the office. If you're working in the office and the clients are coming in, you need to make sure your desk is free of any information about other clients, that your computer screen doesn't have other clients' information on it. When you're at home, you need to be careful not to discuss it with other people. We'll talk in a few minutes about working at home. You're in the coffee shop, you don't know who's sitting at the next table that might be listening. I might overhear. If you're in a building with an elevator with your office and you're in the elevator with other people, make sure that your files that you have with you are in a briefcase, or at least are closed, and that you're not talking about client matters with other people in the elevator. So why is it so important? Well, the rules say that it's the hallmark of the attorney-client relationship. The lawyer needs to make sure that the client understands that everything that they learn, that the lawyer learns in the course of that representation, is confidential, and that they won't be releasing it, so that the client is comfortable sharing whatever information they have, whether it's environment that is embarrassing or detrimental to them, to share it with the lawyer, so the lawyer has the information needed to effectively represent the client. I know most lawyers will run into a situation where they learn about some new fact in the case, either in discovery or when a witness is testifying at trial and says something different from what your client told you. It's really critical that you build that trust with the client to make sure that the client understands that they can tell you everything and that they need to tell you everything if you're going to be effective in representing them. So I mentioned that there's 6068E2, and that says that a member may, but is not required, to reveal confidential information relating to the representation, the disclosure of which is necessary to prevent a criminal act that the member reasonably believes is likely to result in death or substantial bodily harm to an individual. So breaking that out, first of all, may but is not required to. You can reveal it if you reasonably believe that it will prevent a crime. Now, it has to be able to actually prevent the crime, a crime. So if your client tells you they're going to commit suicide, that doesn't give you leave to disclose, because suicide in California is not a crime. So you can't disclose that information. And you have to reasonably believe that it will result in death or serious bodily harm. So if your client tells you something, that he's going to go out and do something harmful, you have to reasonably believe that he's going to carry that out. So when this rule was passed, the first case we saw in the office was a client who called on Monday and said, if I don't have this Social Security problem resolved by Friday, I'm going to bomb the social worker's car. So did we reasonably believe that it would be necessary to prevent a crime? Well, if he thought he would do it, we thought he would really do it, that would prevent a crime if we disclosed it. Do we really believe that it would result in death or bodily harm? Well, he might carry it out, and we don't know if he's going to carry it out. If we reasonably believe he will, and that he'll carry it out in a way that would cause somebody harm, if it's blowing it up in the parking lot when nobody's around, there's no death or substantial bodily harm. So you've got to look at all of those factors, and comments B through E of 1.6 go through a lengthy series of discussions about how you make those decisions and what you do with them once you do. In that case, we never had to face the issue because by Friday we got the problem solved. But it does come up. What I would suggest is anytime you feel you're in that situation, discuss it with a supervisor, go up the line in your organization, make sure that you're comfortable and that the organization is comfortable releasing that information if you decide you want to, but go through the comments B through E to see, what kinds of factors you look at. Does it create a conflict with your client? Do you have to withdraw from the case if you've done that? A whole range of questions that you need to ask before you take that step. So let's talk for a minute about working remotely. First, don't use an open or public Wi-Fi network. If you're at Starbucks and you're using their Wi-Fi network, even though it has a password, it's a simple password. It's not a locked network. And other people can access that information. So you shouldn't do that, particularly if you're using a laptop and somebody could see what's on your screen, or you're on the phone and somebody can hear you. You need to be careful about what you do in public. Keep in mind when we're talking about this, what we're really talking about is any client-related matters. If you're talking to somebody about, where to go for lunch tomorrow, not a problem. If you're talking about setting up a meeting to talk about something, that's not the issue. This is if you're talking about client-related matters. If you're at home, work in private area away from family and any others. Use a headset if that's helpful to you to protect that privacy. Work in a different room with a door closed, whatever. Be sure that as you're using your computer or your phone or your tablet for client information, that you're storing that information on your organization's servers and not on your own devices. The organization's servers tend to be much more effective at protecting the data than personal devices are. Use a VPN or some other system where you're actually working on the servers, not using your own devices, and that the information you're getting isn't saved on your device. Don't conduct conversations in range of Amazon Alexa or Google Home. First time I gave this program, when I said that, the Alexa that was sitting in my office said, "Yes, what can I do for you?" They are listening. Did you hear that? It just said, I'm not quite sure how to help you with that. You need to make sure that it's not listening to what you're saying. I'm not talking about client confidential stuff, so I'm not as worried about it. Be careful that client communications, when you're talking to the client, that only the client can hear you and that the client is in a safe space. Make sure that if you're talking to the client, that nobody else is around. There may, if it's, for example, a family law matter, particularly a domestic violence matter, if the other party is in the room or can hear what you're saying or can access the emails that you're sending the client, you've got to find confidential and safe ways to communicate with the client. It may be that you have to arrange other times and other places to talk to the client. And for supervisors, you need to watch if your employees are working off-site at home or wherever, then you need to make sure that you're watching their work time so that you don't run into wage and hour issues. Move on to conflicts. 4 major rules, 1.3, I guess, 1.7, 1.9, and 1.18. Dealing with 1.7 deals with current clients, 1.9 with former clients, 1.18 with potential clients, and then multiple clients. And we'll talk separately about what happens if you're representing more than one person in a particular case. So, current client, rule 1.7. You can't have direct conflicts. You can't sue your own client, nor can you represent both parties in the same case. That's a no-no. The general rule is if there's a significant risk of a material limitation due to your duty to other clients, former clients, third persons, or your own interests, What does that mean? Is there a significant risk? And it was not just some minor, well, there might be a risk, but it's not really important, but a significant risk of a limitation on your ability to effectively represent your client, to give your client full effect of your best work. If there's some limitation on that because of this risk, then you have a conflict, whether it's a duty you owe to another client or former client, third person, or your own interests. Legal aid lawyers sometimes run into that last one when, for example, you're suing, you have a client who has a case against one of your funders, and there might be some risk to your funding. Well, that's an issue you need to consider before you take that case to decide, is that going to limit how effectively you can represent that client? Now, most of the conflicts that we've talked about can be cured or overcome by informed written consent. And that's a defined term. There's an article that defines very carefully what you have to do. But basically, you have to, in writing, tell your client the circumstances that are involved and all of the potential harmful situations that can result by them agreeing to allow you to represent them, to overcome this conflict. In other words, you got to tell them all the reasons they shouldn't agree. And if they still agree, then you have given them that in writing. They give you a written document that says, I agree, I consent, then you're okay most of the time. Sometimes you can't get written consent. It's impossible. You can't get written consent to represent both sides in the same case. You can't get written consent if you can't ask for it. So, client comes in and you give them service. Another client comes in where the first client is the opposing party. Now, you can't ask the new client for consent to represent them against the former client, because you'd be disclosing the confidential information that you represented the former client. At the same time, you can't ask the former client, because then you'd be disclosing information that the new client had come in to see you. So in that situation, while theoretically it could be overcome with informed written consent, you can't get consent because you can't ask for it. But even with consent, you can't represent a client unless you believe that you can provide competent and diligent representation. So if there's something about the case or the client that makes it so you feel that you cannot provide the best possible competent and diligent representation to that client, you have to decline because of a conflict, even though they've consented to it. That's true of every case, even if it's not because it's consented conflict, even if it's a case that doesn't have a conflict, but the conflict is that you don't believe you can personally represent them effectively, then you have to decline that case. Former client, Rule 1.9. You can't represent a new client in the same or substantially related matter as a former client where the new client's interests are materially adverse to the interests of the former client. And again, it has to be the same or substantially related matter. Doesn't have to be the same case number. It just has to be somehow related. And the new client's interests have to be materially adverse. Again, not just minorly, but materially adverse to the interests of the former client. So if what you're going to do for this client is going to have a negative reaction on the former client, you can't do it without informed written consent. And even if you get consent, even if you can represent the new client, you can't use any of the information that you got by virtue of your former representation that's protected by 60680 or 1.6 to the disadvantage of the former client. So you can't, even if you can, it's not a substantially related matter or whatever, you can represent them. You can't use any of the information you got from the first client against them in representing the second client. So you have to decide then, is if you can't use that information, can you still give diligent and competent representation to the second client. Same kind of discussion we had before. Now, the prospective client, Rule 118. This is a relatively new rule in writing, but it's been assumed before that. If someone contacts you for the purpose of retaining the lawyer or to secure legal services or advice, then they are a prospective client. They want to be a client. And even if no attorney-client relationship is formed, they have the same confidentiality rules as a former client does. So you can't take the case if it's substantially related to the former client's case, and there'd be material harm to the client if you did. This often comes up where a client comes in to see you, gives you information. Maybe you don't accept the case for some reason, but you've got their eligibility information, basics of the case. Then the other side comes in to see you, and you say, I've already talked to the other client. I have a conflict here. They're equivalent of a former client, so therefore I can't take the new case. Two issues. First of all, the only thing you can tell the new client at that point is, we can't help you. You can't go anything beyond that. If you say you can't help you because of a conflict, now the second client knows that the other client has been to see you. So you can't say anything more than, I can't help you. And the best thing after you've said that 2 or 3 times and they keep complaining, you say, let me give you my supervisor, or here's our client grievance procedure. You can't push it, even no matter how hard they push. Let somebody up the line deal with that. The other thing is that in rare occasions, if you can establish that the purpose of them coming to see you was not to secure legal services or advice, then they're not a prospective client. I had one case in many, many, many years that we felt that was the case. The client came in, the first client came in seeking help for a divorce. They were not, I forget whether they weren't eligible or we decided not to take the case for some reason. Later on, the wife comes in and says, can you help me? Brings in the papers that show that the client was represented by counsel, and that both the lawyer and the client had signed the divorce papers and filed them before the husband came to see us. We said, this sounds very much like what he was trying to do was to disqualify us so his wife couldn't get a lawyer. So we went ahead and took the case and used the information we had from him. They never raised the question. They never challenged it, so we never got to test that theory. But that was the only time I ever saw that happen, where we were confident enough to go ahead and go forward with that. It's important when you are interviewing a new client that you don't get any more information than you absolutely need. So once you find out that they're not in your service area, stop anything further. If you find out that their income is too high, don't go any further with the intake. Get as little advice, little information as possible so you don't run into this problem. There's a recent case called Sire versus Douglas that seems to say that legal services attorneys are different than private attorneys on this rule, and that maybe it's okay to take that client. I think that's a badly reasoned decision. Nobody has cited it. There's a good article that if anybody's interested, I can provide that explains why it's a horrible decision and really totally misses the boat on what ought to be the law. So just keep that in mind. Dealing with multiple clients. So you have more than one client coming to see you about the same problem. Maybe it's a husband and wife being evicted or with a consumer problem. Maybe it's 4 tenants in a building that want to sue their landlord. Maybe it's a bunch of employees wanting to take a wage and hour case against their employer. Anytime you have more than one client in the same matter, you have multiple clients and you have a potential conflict there. So 1.7 requires informed written consent to accept or continue that representation. You must disclose all the potential adverse consequences to get that informed written consent. And there's a good article about this, by the way, in the materials. Some of those are, that Evidence Code 962 says that while anything they tell you is privileged as to the outside world, anything they tell you is not privileged as to each other. So if they later get into some kind of dispute, you can be called to testify to anything either one of them told you, because there's no privilege when you've got that. The same is true of confidentiality. You've got to make sure they understand that whatever one of them tells you, you can tell the other, because under Rule 1.4, you have an obligation to keep the client informed of significant developments in their case. Well, if one of them gives you information that affects the case, you have to, under 1.4, disclose that to the other. So you need to make sure that the clients understand that if they tell you something harmful to the other client, you have to be able to tell that client. And they need to understand that before they tell you anything. They need to understand that if they do get into a conflict, you may need to withdraw from representing both of them. What happens if they give you conflicting instructions or have conflicting interests in the case? Outside of the conflicts issues, there's some other things you ought to discuss up front in any case where you're representing more than one. If there's likely to be any kind of recovery, for example, the situation with the tenants or the employees, and it's going to be a lump sum rule or lump sum recovery, you need to look at Rule 1.8.7 and talk about how they're going to decide who gets how much of the recovery, if it's a lump sum. At the end of a case, the client is entitled to their file. But who gets it if both clients want it? Easy to resolve up front when you say, if that situation arises, A gets the file and B gets a copy. It's not easy to resolve at the end of the case when they've come to you now and say they both want the file. And is it possible that one client can remain with the attorney if an actual conflict arises? Can you get an advance consent that says if something comes up and there's a conflict, we agree that you can continue to represent wife and not husband, or some other way of deciding? It can't be the lawyer's choice. It can't be something like that. But at any point, you can have an agreement that says, if that happens, here's what's going to happen. So all of those things are important to talk about and discuss with the clients before you get into that situation. Okay, so but that's the common issues in regular practice. Now some common issues in legal services. Let's start with interpreters. It's really important to use qualified interpreters, people who understand three key things: both languages clearly, the purpose of the interpreter to take all the words you say and translate them to the client, all the words the client say and translate them to you. And third, their requirements for confidentiality. Very often you see a situation when there's not a competent interpreter where you'll ask a question, the interpreter conveys it to the client responds, interpreter responds to the client responds to the interpreter, goes back forth two or three times, and then the interpreter comes to you and says, she says yes. Well, that's obviously not all that was said. The interpreter needs to understand all of that and convey everything to you. The the risks of having somebody who's not a competent interpreter, and I would suggest either a staff member who's competent, a qualified interpreter through something like Language Line or one of those kinds of organizations, is really the best. And if you're not going to do that, if the client insists on bringing their own interpreter, you need to get a written consent from the client that they understand they could get a qualified interpreter, but they want their friend or their family member to be the interpreter. The risk with those kinds of things is that, and then the interpreter, whoever it is, needs to be trained on what it is their job is and on confidentiality. The risk is that if the interpreter has some kind of stake in the outcome, they may shade what's being said. Maybe it's the neighbor, and the neighbor likes the husband better than the wife, so she's not going to interpret the words exactly to favor exactly what the wife says, but something sort of shift it in ways that might favor the husband. The worst situation I see is a child coming in to interpret for mom on a domestic violence case. And you're sitting there with the 13-year-old daughter explaining all the horrible things that dad did to mom. Terrible situation and ought to be avoided in any way you possibly can. And there's an article that discusses all of these things about the importance of that. Clinics, Rule 6.5. This is one of those places where the rules are different for legal services. If you have a clinic run by a legal services program or a court or a nonprofit or a bar association, a law school, that conflict checks are different. You don't have to run a full conflict check if you're not able to. And the only conflict check that's required is what's called a visual conflict check. I see the client, I see the name, I see the opposing party. I'm not aware of a conflict that I have. I'm not aware that anybody in my firm has a conflict with that, so I can go ahead and provide the information. The limit on that is it can only be for what happens at that clinic. It can't go beyond what happens at the clinic. At that point, if you go beyond that, then you have to do a full conflict check. So it's important to make sure that if you're using 6.5, that it's that you stick to that and that the lawyer sticks to that. This was designed really so that pro bono lawyers could provide help without having to run back and run through their law firm, their international law firm conflict check system that takes 2 weeks when the client has an eviction to answer. So that was the reason they did it, and it allows that, but you got to be careful that you stick to what's covered by the clinic and nothing more. Limited scope, Rule 1.2b. Most of the things that we do in legal services are limited scope. In fact, most of the things that most lawyers do are limited scope because they take on a case. They may take on a case till the end of the case, but they may not agree up front that they'll cover appeals, collections, other issues, extraneous issues, or beyond the case itself. So limited scope is covered by Rule 1.2b, and it basically says that you have to make sure that the client understands the limits and that you can and that it's reasonable for the client to be in that situation. Otherwise, you can't do it. Diminished capacity is a common problem that comes up frequently and gets a lot of questions. If you're in an ABA state, you've got Rule 1.14 that gives you a lot of guidance on what a lawyer can and can't do, all the way to the point, if in extreme cases, that the lawyer can actually file a guardianship or conservatorship proceeding against their own client. California doesn't have a Rule 1.14. The Rules Commission that drafted the current rules proposed one that didn't go that far, but the court, Supreme Court, when they adopted the rules, didn't adopt that rule and didn't say why. But we presume it has to do with the fact of how rigid California's confidentiality rules are, much more so than any other state. So the Ethics Committee of the State Bar, the Committee on Professional Responsibility and Conduct, did adopt an opinion that laid out what to do in the case of diminished capacity. A copy of that's in your materials. It basically says you've got to attempt to treat the client like you would any other client. They need to treat them as normal as possible, meaning you give them, you explain things to them, you try to get their understanding, their consent. Understand that capacity is really not a single thing. Under the codes, you can have capacity to do things and not capacity to do other things. So capacity to dispose of property on death, testamentary capacity, is a very low standard. Capacity to wed is a higher standard. Capacity to contract is an even higher standard of what it takes. And mostly we're dealing here with capacity to contract. But also it's something that can come and go. So if somebody comes in to see you, and because of their current condition, whether it's abuse of substances or some other reason, they don't have capacity, that doesn't mean that tomorrow they won't be just fine. So you can't assume that they're always going to be without capacity when you start. So you need to really think through, how can I help this client if they appear not to be able to understand? Can I bring someone in? Can I bring in an expert, somebody who deals with, a psychologist or a social worker that might be better able to communicate with them? That would be acceptable. Can you bring in a family member? That's more problematic because you'd need their consent to do that. Sometimes they have capacity, they'll understand that, and you can say, can I have your daughter come in and help us with this? There's always the risk that you'll choose the bad son instead of the good daughter if you're choosing which family member it is, but it's something to look at. Ultimately, if you can't communicate with the client effectively, you can't get them to agree to what needs to be done, you may have to withdraw. And that's the worst outcome, because then they have nothing. So you need to do everything you can to keep with them. There's also in the opinion a discussion of something called advance consent, where they can say, if I become incapacity, have diminished capacity, you have my consent to trust my daughter on this, or some other. Important that you don't rely on that at any great distance in time, because situations change with people, but it's something to take a look at if you want to look at that. And it's in the opinion. Opening and closing letters. These are, to me, some of the most critical items you're going to deal with. The retainer agreement, or whatever agreement you have that begins your representation, needs to include not only, the information about what the case is, but what you're going to do, what you're agreeing to do on that case, and maybe more importantly, what you're not agreeing to do, and that the client is responsible for on their own. So if you say, we're going to help you, I'm going to interview you, determine what's the appropriate course of action, I'm going to prepare legal papers to file for you, but you're going to file them yourself, you're going to represent yourself in court. If further papers come in, you're on your own for discovery or motions or anything else. You need to make that real clear up front. And let me make it clear why. I'm aware of at least 2 cases involving legal services where the lawyers did that and then went past what they said they were going to do. And bad things happened after that. One case, the program had a 7-figure verdict against them, and in the other, it was a substantial settlement that occurred because they went past what they said they were going to do. Once you do that, you're now on the hook for the entire case. if you decide you want to do the next step, client comes in and says, I've got these interrogatories, what am I supposed to do with them? You say, well, I'll help you answer them. Let's sign a new retainer that adds that on to what I'm going to do, but continues to say, that's the limit. I'm not going to go beyond that. And that's fine. Just make sure each time you go past, you have a new agreement that says that's okay to go past and not further. Closing letter is a different matter, and there's a good article on that one. The closing letter says, thank you for allowing us to serve you. Here's what we did for you. We did A, B, C, and D. Here's copies of any documents you might need, a copy of a settlement or a judgment, and the like. Here are things you still need to do to complete this transaction. So in the settlement, you agreed you would move out by May 15th. You need to make sure you move out by May 15th. It also discloses anything that you are aware of that might be a matter that the client has a case about, but that you're not going to handle and not interested in handling, but you're aware that it exists. There's a case in which a lawyer handled a workers' compensation case, handled it perfectly, got a great result, and got sued for malpractice. He got sued for malpractice because he didn't tell the client that the client had the possibility of what's called a third-party claim, which means the workers' comp case is against the employer, but if the injury on the job was caused by a machine, he might be able to sue the manufacturer of the machine. He didn't tell the client that. Court said he's got that obligation. Doesn't have to represent him on that, but has to tell him, you may have this claim. If you should go see another lawyer to talk about that. There may be a statute of limitations to worry about. That's all got to be spelled out in that closing letter. And then the last thing is, we're done. Nicer words, but we're done. Never cross my doorstep again. And if you have a new case, come back through the process of intake, and they'll look at it again. But for this matter, we're done. And thank you for allowing us to be of service to you. So that's it. One of the other important things about that is that it does start the statute of limitations running on any claim for malpractice, because you've advised them that your case is over, that your representation is over. Rule 1.8.5 is another one of those cases where we've got a difference. 1.8, the basic 1.8.5 rule says that you can't pay the personal or business expenses of a client. And there's always an exception that you can advance things like court costs or expenses, subject to being repaid at the end of the case or out of the results. And then you can always cancel that debt if you want to at the end, but it has to be set up as an advance rather than a payment. But there's a provision that says that it's okay to pay the costs of prosecuting and defending a claim or action, or of protecting or promoting the interests of an indigent person in a matter in which the lawyer represents the client. So you can not only pay the claims and expenses, the copying fees, the postage, those kind of things, but also you can pay the costs of protecting or promoting the interests of the client in the matter. So what does that mean? It means, I think, that you can buy the client breakfast on the way to court so that he comes in coherent. You can give them a taxi voucher so they can get to court or to your office. They can come in, probably, buy them some clothes if they don't have competent court clothes to go be in court. The question usually comes up is, can you pay the rent in an eviction case? And my answer, I'm not sure agrees. In fact, I'm sure it doesn't agree with all of my ethics colleagues, but it is, my view is that within limits you can. So if it's a $50 late fee that you're talking about that will settle the case, yeah, I think you can do that. That advances the client's interests, definitely advances the client's interest in the case. If it's, a $4,000 back rent, I think that probably is excessive. But where the line is, I can't tell you, but it's again, back to that rule of reason that we talked about at the beginning, that you need to think about how that works. But that's, again, another one of those places like 6.5 where the rules are a little bit different. Working with co-counsel. The important thing of working with co-counsels is that you need to make sure everybody understands who's doing what. There has to be a clear understanding and agreement of each person's role and responsibilities and authority, and what's going to happen if there's a conflict between co-counsel. How's that going to get resolved? Who has the final say? We had one case where neither side was willing to say that either lawyer could have the final say, but they agreed that if there was a disagreement, they would go to one of the two, I forget which one, executive directors, and they would make the final call. So whatever the agreements are, it needs to be careful. Who's going to prepare discovery? Who's going to question the witnesses? All those things, as much as you can spell those out in advance, the better. And if it's in writing, that's even better. Everything's better if it's in writing. Supervision of lawyers, rule 5.2, supervision non-lawyers, 5.3. And it applies to lawyers too. 5.1 applies to lawyers and basically says that if the client is, that the management of the organization has responsibility to make sure that the systems are in place to allow the staff, whether it's lawyers or non-lawyers, to comply with their ethical obligations. So management has to make sure that there is a good conflict check system, that there's training on ethics, there's other good training programs on competence issues, and so forth. The supervisor, the direct supervisor, needs to make sure that their supervisees, lawyers or non-lawyers, are following those subjects, are taking the training, are doing the conflict checking, are keeping calendaring, making sure that their cases are moving along, that they're not allowing cases to lag. There's a case of a pro bono lawyer, Supreme Court case, where the pro bono lawyer got busy and put aside a couple of pro bono cases to work on his paying cases. And the Supreme Court suspended him for a year. And the then Chief Justice would have suspended him for 3 years for that. So all of those things are the supervisor's job to make sure that those things are going on. The interesting difference with the non-lawyer rule, 5.3 as opposed to 5.1, is it makes clear that it's not just non-lawyers who are employed by your organization. It can be volunteers, it can be community workers that are working with you. Any non-lawyer that's working on your matter needs to be under that supervision and needs to meet those requirements of making sure that for lawyers that they live up to their ethical requirements, to non-lawyers that they understand they have to do things that will comparable to what the lawyer's ethics are, so they're not putting the lawyer's tickets on the line. The one rule about that is that the supervisor isn't responsible for what the either subordinate lawyer or subordinate non-lawyer does unless they ratify it or, knowing of it, don't take steps to prevent it or mollify it. They can be held responsible for not supervising properly. That's a disciplinable offense, but they're not responsible for what the non-lawyer or subordinate lawyer did unless they consented to it or approved it. So do we have some questions?
We have a few in the Q&A. They're a bit long, so I'll start with the first one. It says, can you discuss the rules of confidentiality for potential clients and if or how it covers people who apply for legal aid services, but when we decline services and the person never speaks with the attorney? We've had situations where we've declined services for various reasons, ranging from out of program scope to the person was verbally abusive to staff, and then a referring agency or social worker asks us why we can't help.
Okay. The information that you get from a client is confidential, and whether that's they live outside our area, or it's a kind of case we don't handle, or they were abusive to staff, whatever the reason for not taking it, that's confidential information under 60681 and under Rule 1.6, which means that you can't share it without the client's consent. When the social worker or the agency that referred you called, all you can say is, we can't help. Based on our requirements and our ethical standards, we're unable to help this client. You can't go into the reasons because that is confidential information. Okay. Next.
Next one says, do you think the ethical rules require a closing letter to notify clients of statutes of limitations and or potential claims? For example, we defend a client in an unlawful detainer case where habitability issues were raised in defense. Should the closing letter state the statute of limitation for such claims and provide the types of claims and or referrals to outside counsel for those claims?
That would be ideal. I think that's an excellent thing to do. I think you need to say, you may have a claim against your landlord for the conditions you were forced to live in. If you want to pursue that, you need to pursue that through, another attorney. We don't handle that. And, you can give them whatever your referral protocols are in your program. Most programs, it's through some kind of lawyer referral service rather than specific, direct referrals. And if you know the statute of limitations, that can be a little difficult because it may depend on when the conditions started or when they ended or various things like that. It's safer, unless you really are familiar with the facts enough to say this is when it is, to just say there may be a statute of limitations involved here and you should, take action soon to get a lawyer if you choose to. But that's always a risk that you'll get it wrong and that the client will lose the case because you told them a statute of limitations that was too far out.
Next one says, any comments on attorney solicitation and how to follow up with the Committee on Professional Responsibility and Conduct?
Well, Committee on Professional Responsibility and Conduct really is just a committee that issues opinions. They're not the ones that handle the discipline. That's the State Bar Court, the State Bar Discipline Department that handles complaints. And it depends on what kind of solicitation you're talking about. If you're talking about a private attorney who's actively soliciting clients, the rule on that, give me a minute and let me find my rule book here. Where did it go? Oh, come on. Should be right here. There it is. I think, yeah. It's rule 7.2. Two, 7.3. Lawyer can't in person, live telephone, or real-time electronic contact solicit professional employment when a significant reason for doing it is the lawyer's pecuniary gain, which is said because it's okay for us to do that. Private lawyers who want financial gain can't. You can't solicit by written, recorded, or electronic communication, or by in-person telephone or real-time electronic contact, even when not otherwise prohibited by A, if the person has made known they don't want you to. And then there's some other things about advertising and stuff. But the main thing is that the solicitation limit really is based on in-person contact, either in person or by telephone, by text, by other electronic means. But it has to be the issue is it something that can, if it's an email, that's probably okay because they don't have to respond. They're not sitting there looking at you or expecting an immediate response. That's okay. It's if you're in person or on a chat line of some sort where you need an immediate response, those are the kind of things that are prohibited. If you feel there is a situation of a solicitation by a private lawyer, you can file a complaint, or the client can file a complaint with the state bar. It's a simple procedure. It's on the state bar's website. It's a form, and whether they will do anything about it may be a different question. It may depend on how severe and extreme it is, but that's the process. Okay.
Next one says, when does publicity of a fact negate confidentiality? For example, court filing in non-sealed form.
Okay. Confidentiality is funny that way. The rule is that if you learn information about a fact, about the client, there's some information that's confidential, the fact that it's in a public record does not make it public. It makes it public to the rest of the world, but that doesn't relieve you of your obligation of confidentiality. The rest of the world can say, my client was arrested for drunk driving. You can't say that if you discovered that in the course of your representation of that client. It may seem a little odd, but that's the rule. And if it's buried in a case in the courthouse, it's still confidential. If somebody says, if there's a filing in court, that may not be privileged. It may not be confidential as to the rest of the world. You may not be able to talk about it, but a reporter can find it in the court file and they can do whatever they want with it, or somebody else can find it. Sometimes you'll do a press release about a filing, and that's okay if the client approved it. That's the key, is getting client consent on those kind of things. Now, if it was on the front page of the LA Times, some people will argue that makes it public and that you don't have to worry about that. That's an exception, is publicly known in the field. It's not clear in California how that applies, but it probably does. Now, if it's on the back page of a local throwaway rag, that's probably not enough to say that it's public. Okay.
The last one's just a comment. Someone said the ABA has a model retainer for practitioners. I think that's it.
Yeah, I don't know that I've seen an ABA model. California has some model retainers, but most of those are really aimed at private lawyers and deal with fee issues substantially. And they don't address things like limited scope and the how you lay out those kind of things. Some of these things are so fact specific that a form might not be adequate or might not really help that much. You can have a format that says, here's how we lay it out, but if you're laying out, here's what we're going to do for you and here's what we're not going to do for you, that might be different in every case. If you've got whatever the issues are, each fact situation is going to be different. Same is true with a consent, an informed written consent to multiple clients. You can have a basic format, but you need to fill in a lot of blanks as to here's what the situation is in this particular case. You need to be careful that you're not, you know, using a form that might not accurately depict what's going on in this particular case. I'm not familiar with the ABA's form. As I say, the state bar has forms for both fee cases and contingent fee cases, hourly cases and contingent fee cases. But I'm not sure how helpful they are to legal services programs.
And I think that's it for the questions.
Okay, let me take a couple of minutes with just a few other thoughts. One of the things that happens in these programs is that people get afraid because of some of the things I've said. Oh, I can't do that. I can't do that. Again, remember, these are rules of reason. You've got to think through what is it that's really going on here and how do I do that? Particularly pro bono lawyers sometimes get freaked out when we talk about what are the bad things that can happen. But keep in mind that, there's a reason we have malpractice insurance. Better not to do that, but, it's there to protect you. But it's important to continue to be aggressive and zealous in your representation of your clients. That's the other piece of it, is the issue of competence and diligence. You need to, that issue of competence, you need to really, push what you need to do to represent that client most effectively and timely, to make sure that you're helping your client to the best extent possible. And with that, I think we've pretty much hit the deadline.
Thank you, Toby.
One more slide. Let's do that. And there's how to reach me. What I do is I provide training and like this, and answer consultation questions for legal services programs in California. I'm available to, respond to a question. If you have a question, talk to a supervisor, see if you can resolve it internally. But if not, text me or write to me, call me, and we'll see if we can work through it with you. If your program needs a specific training on a topic, I can do that. So let me know.